Hi, my name is Danielle Fisher, and I am presenting on testamentary capacity. This is chapter 11 in our textbooks. What is testamentary capacity? This can be described as the competence to execute a will or to validate one. Is or was the individual of sound mind when their will was created? This is not an evaluation of general competency, rather, it is the legal capability to prepare a valid will. Generally, only a low threshold of capacity is needed. There are four legal requirements to confirm testamentary capacity, and these requirements were established in 1870. In the case of Banks versus Goodfellow in 1870, John Banks had a large estate and he had mental illness, which included delusions and epilepsy. For example, he believed that someone was following him even though this person was already deceased. John Banks created his will in 1863, stating that he wishes for his property and assets to be given to his niece. His heir at law, William Banks, wanted to contest this will due to John Banks not being of sound mind. However, John Banks was considered sound of mind, and his property and assets were given to his niece. In many cases, mental illness does not directly mean testamentary incapacity. This is when the four legal principles that test testamentary capacity were created. The first legal principle is that testators must know at the time of executing their will that they are creating one. The individual creating their will is required to understand what a will is, and they must know that they are currently making one. Some questions to ask the individual is, why are they creating a will now, or why are they updating their will from a previous one? Ask the individual, what is a will, and what does a will do? These questions can help shed light on any possible delusions contributing to the creation of their will or their inability to understand what a will is. The second legal principle is that testators must know the nature and the extent of their property. The individual must understand what assets they currently and realistically have. You could ask the individual about their prior occupation and their salary, ask them about their current housing situation and their personal possessions, and ask them about their bank account and any potential investments that they might have. It is important to make sure these questions are open-ended, such as, describe to me your current living situation. Is this description realistic? The third legal principle is that testators must know the natural objects of their bounty. The individual must have an understanding of who they have decided to inherit their assets and a just reasoning for excluding individuals. Some of these questions that an evaluator could ask include, who are your loved ones? Please identify your friends, family, or any others who may have played a major role in your life. And how do you feel about these people you have identified? These questions can help determine if the testator is in any way being isolated or controlled by others, and if they have deluded reasoning to exclude someone from their will. It is important to note that just because the testator may have hostility or prejudice towards an individual close to them, this does not necessarily mean that they are incapacitated. The fourth legal principle is that testators must know the manner in which they are executing their will distributes their property and assets. This individual must understand how their property and assets will be distributed amongst individuals or places that they have chosen in their will. Some of these questions could be, is a testator aware of any general consequences of their property dispersion? For example, if someone decides to leave only $1 to their daughter and the rest to a charity, was this a mistake? Or do they have a bad relationship with their daughter? Or is their daughter in a good financial position and there may not be any consequences? It is important for the evaluator to investigate the reasoning behind these choices, but not to judge if these choices are appropriate. Along, along with testamentary capacity comes the issue of undue influence. Undue influence is when someone exerts pressure or coercion onto another, causing the testator to alter their will unjustly for another person. Some signs of undue influence include sudden isolation from family and friends, a sudden change in the testator's will, disproportionate dispersion of assets and property, usually favoring one person? Does the testator seem vulnerable, fearful, or confused? And is the favored person in the will always present during legal arrangements, trying to have control of the situation? In the case of undue influence, people are allowed to try and persuade a testator. However, when this influence drowns out the testator's free will or their intentions, it is then considered undue influence. Testamentary capacity is on the rise. There has been an increase in the request for individuals to be expertly consulted due to will contestments. This is most likely due to an increase in blended families, intergenerational wealth, and an increase in elders with cognitive impairments. So, how can clinicians help? Clinicians can evaluate a testator when they're alive. However, the majority of a testator's capacity is brought up after they have passed away. To prevent contests of a will, it is recommended to have an evaluation after the execution of your will, along with having this evaluation recorded. If this is recorded, it could be drawn upon to prove testamentary capacity or as a baseline of testamentary capacity for a revision of the will. However, if the individual has passed away, the evaluation is similar but draws upon more of third-party factors such as friends, family, medical records, etc. Overall, clinicians provide neurological and physical examinations, interviews, intelligence tests, and a careful collection of outside information and evidence. My discussion question that I posed to the class is, how should the examiners differentiate between undue influence and respecting the testator's individual decisions about the dispersions of their assets and property? How would you examine if this was due to persuasion or undue influence? Lastly, I have provided a YouTube video that is around 5 to 7 minutes, not too long. And this video is about a legal expert explaining the definition of testamentary capacity, establishing the importance of testamentary capacity during the execution of a will, and further explains how other legal measures such as guardianship can help individuals in the dispersion of their assets and property. These are my references for this presentation. Thank you so much for learning with me.